My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this morning for what we call an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. The case that you have in this court is a criminal case. We handle misdemeanor cases. Criminal cases are divided into felonies and misdemeanors. Your felony cases are normally referred to as your more serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony case. And when I use the term serious, what I'm talking about is the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories, and we'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about that punishment for felonies because, as I mentioned earlier, we handle misdemeanor cases. Misdemeanors are divided into 3 categories, and we'll start at the top and work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, the Class C misdemeanors are cases that start or originate in the JP court, which is the justice court, or the city court, which is the municipal court. Those cases come to this court when a person is convicted in the JP court or the city court and they appeal their case. And then it comes to us and they get a whole new trial. We call it a trial de novo. Now, if a person is convicted of a Class C misdemeanor, the range of punishment is minimum $0 to a maximum of $500. They cannot be given jail time. However, if a person failed to pay the fine, or if the fine was converted to community service and they failed to perform the community service, then the court or the judge can issue what is called a capias pro fine. That's a warrant for the person to be arrested to sit out the fine. Now, if they sit out their fine, they will be credited as $100 per day toward the fine. Now, if a person is convicted of a Class B misdemeanor, the range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days, which is 6 months in the county jail, or a fine that does not exceed $2,000, or they can be given both such fine and confinement. If a person is convicted of a Class A misdemeanor, which is the highest misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or a fine that does not exceed $4,000, or the person could be given both such fine and confinement. Now, a person may be eligible for probation. There are 2 types of probation. One type of probation is called adjudicated probation. Adjudicated probation. The other type of probation is called unadjudicated probation. Now, the difference between the two is as follows. If a person is convicted of, well, if a person is given unadjudicated probation, they will not have a conviction on their record. And if they successfully complete the probation, the case will be dismissed. They will not have a conviction on their record, and they may qualify for what is called a non-disclosure. And what a non-disclosure is, it basically means that your record is sealed. That is, we can't disclose to the general public that you are on deferred probation for this case. Now, I use the term general public, and that just basically means that the general public cannot have access. However, the government or governmental agencies and departments, depending on if they are listed in the Code of Criminal Procedure, they can have access. But most of the public is general public, so they cannot have access. Now, if a person is given adjudicated probation, with adjudicated probation, they have a conviction on their record. However, the court or the judge can set that conviction aside by what is called judicial clemency. And the way it works, a person has to complete the probation, cannot have any more time left on the probation, and they have to be successfully discharged off of the probation. If those three things happen, then the court or the judge has the discretion to set aside the conviction. And if the court sets aside the conviction, you will no longer have a conviction on your record. Now, however, if you get a subsequent conviction or another conviction later on, then the case that you receive judicial clemency on can be resurrected, revived, brought back up, and used against you. Now, if you try to get a license with CPS, your license, they could either deny giving you a license, or they could revoke or suspend the license that you have if you had judicial clemency and then you get a subsequent conviction. Now, as a defendant in a criminal case, you have rights. And I'm going to go over the rights that you have. One of the rights that you have is a right to have an attorney. On the clipboard that you have before you, you'll see a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. On that document, talk about your rights to have an attorney. Now, it basically states that as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you want an attorney but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date to give you time to hire your attorney. Now, if you want an attorney to represent you, but you do not have enough money to hire an attorney, then you can request that an attorney be appointed to represent you. Now, before you do that, you have to first sign a financial affidavit. The financial affidavit that you have to fill out and sign is the document on the clipboard that is titled Jefferson County Affidavit of Indigence. You will have to fill out the first page of that document and the top half of the second page. And then I will fill out the bottom half of the second page and the third page. And then once you fill out that document, the proper person will review the document to determine whether or not you qualify for the appointment of a court-appointed attorney. Now, if you want to represent yourself, that is, waive or give up your right to have an attorney, and you want to represent yourself, then you would have to sign a waiver. The waiver on the clipboard is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding the trial. You will only have to fill out that document if you are desiring to represent yourself. If you're not desiring to represent yourself, you don't have to fill out that document. So let me repeat that. If you're desiring to represent yourself, you not only have to fill out the judge's explanation, but you would also have to fill out the waiver. If you are requesting a court-appointed attorney, you fill out the judge's explanation and the affidavit. Those are the only two. Now, if you are requesting to have your case reset to hire your own attorney, then you would only have to fill out the judge's explanation of rights, okay? And that's the first document that we went over. Now, if you are representing yourself, you filled out the affidavit, you'll have an opportunity, or if you fill out the waiver, you'll have the opportunity to talk to one of the prosecutors. Prosecutors are sitting at the table before you. They work for the Jefferson County District Attorney's Office. They are assistant criminal district attorneys. You'll be able to talk to them about your case, about settling your case. Now, the reason why you'll be able to talk to them is because at that point, when you sign a waiver, you are representing yourself. In essence, you are acting as your own lawyer. Okay. Now, you'll have, as I mentioned, you'll have an opportunity to talk to one of them about seeing if you can settle your case. Now, the other thing is this. There are dangers and disadvantages to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Now, if we look at that first document, Judge's Explanation of Rights to Defendants Without an Attorney, at the bottom of that document in bold letters, it says defendant's choice. Mark initials next to one choice. If your choice is to hire your own attorney, then you will place your initials on the first line to the left. Now, if you have already hired an attorney to represent you in your case, well, you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to request a court-appointed attorney, then you will put your initials on the third line to the left. If you've already been appointed a court-appointed attorney to represent you in your case, then you will place your initials on the fourth line to the left. If your choice is to represent yourself, that is, to waive your right to an attorney or to give up your right to an attorney and represent yourself, then you will place your initials on the fifth line to the left at the bottom. Now, once you have finished initialing one of the 5 lines at the bottom of that document, then you will sign your name on the line that is titled defendant, and you will date it today's date, August 20th of 2024. Now, for those individuals who will be waiving their right to an attorney and be representing themselves, I'm going to go over the waiver of counsel for purposes of entering a guilty plea or proceeding to trial with you. And it states as follows. I have been advised of the nature of charges against me and the disadvantages of self-representation. My waiver is voluntarily and intelligently made. Now, when you use the term voluntarily, what are you saying? You're saying that you're doing this of your own free will. No one is forcing you to sign this waiver. You're voluntarily doing it. And when it says intelligently made, you're saying that I know what I'm doing. So my waiver is voluntarily and intelligently made. Furthermore, I have been advised this 20th day of August of 2024 by the County Court at Law Number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel. One will be appointed for me free of charge, understanding my right to have counsel appointed to me free of charge. If I'm not financially able to afford counsel, I wish to waive, which means I wish to give up that right and request counsel and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right. Ma'am, that door is closed. You got to go to the other door. I hereby waive my right to counsel. Miss Mosby, could you turn the camera toward the folks in the gallery? And if that is your choice, then you will sign your name on the line that is titled defendant, and you would date it today's date, August 20th of 2024. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. Thank you. That area over there, we call it the jury box. 6 citizens will be selected to serve as jurors in your case. They will listen to all of the evidence. They will listen to the arguments. They will deliberate, and then they will decide, after deliberating, whether or not to find you not guilty or guilty. You also have a right to waive or give up your right to have a trial by jury. That is, you have a right not to have a trial by jury. And if you waive or give up your right to have a trial by jury, then your case will come before the judge or the court in one of 3 ways. One way it can come before the judge is by way of a trial. We call that a bench trial, where the judge will be the judge and the jury in the case. The judge will listen to all of the evidence, the arguments, and then the judge will apply the facts to the law, and then the judge will decide whether or not to find you not guilty or guilty. The other way that your case can come before the judge is by way of a plea bargain. Now, a plea bargain is an agreement that you make with the state, the district attorney. We call that that's an agreed plea bargain. Or you can have what is called an unagreed plea bargain, whereby you and the state have not been able to reach an agreement on your case, and so therefore you want the judge to decide what your punishment will be in the case. Now, if you have an agreement with the state, then it will come before the judge, and the judge can do one of 2 things. The judge could either accept or reject the plea bargain agreement. If the judge rejects your plea bargain agreement, you can take your plea back. For example, let's say you and the state have reached a plea bargain agreement, and the agreement is for you to receive deferred probation, unadjudicated probation. And then the judge says, well, I'm going to reject that plea bargain agreement. Then you can say, well, judge, since you're not accepting my plea bargain agreement that I made with the state, I take my plea back, or I withdraw my plea of guilty of no contest. You can do that. Now, if the judge does follow the plea bargain agreement, and if you decide within 30 days that you would like to appeal your case, you have to get permission from the judge to appeal your case. And what an appeal is, it means that you'll be asking a higher court to review your case. Okay, that's what an appeal is. Now, and that higher court can do one of 2 things. They could either grant or deny your appeal. If they grant your appeal, they could just simply find you not guilty, or they can send the case back down to this court, or to this court to give you a whole new trial. If you decided that you wanted to appeal it to a higher court than the 9th Court of Appeals, which is on the 3rd floor, you can appeal it to the Texas Court of Appeals, which is in Austin, Texas. You would have to file what is called a pro se petition for discretionary review. They can do one of 2 things. They can grant or deny your pro se petition. Now, pro se means that you're representing yourself. You won't have a lawyer representing you, so they can either grant or deny it. If they grant your pro se petition, they can simply find you not guilty, or they can send the case back down to the 9th Court of Appeals, order them to make additional findings, or they can send the court back to this court and order us to give you a whole new trial. Now, if the Texas Court of Criminal Appeals deny your pro se petition, then at that point your conviction will stand. Now, As a defendant in a criminal case, you also have a right, as I mentioned earlier, to come before the judge by way of an unagreed plea bargain. An unagreed plea bargain simply means that you and the state have not been able to reach an agreement concerning your case, but you want the judge to decide what your punishment will be in your case. And the punishment will be within the punishment range of your offense. That is, if it's a class A misdemeanor, range of punishment, minimum 0 days to maximum 365 days of fine that does not exceed $4,000, or you can be given both such fine and confinement. Or if it's a class B misdemeanor, it will be in the range of class C misdemeanor be in the range. Okay. Now, the other way that your case can come before, the other right that you have as a defendant in a criminal case is a right to have witnesses to come to court. And what witnesses do, they sit in that chair right there. We call that the witness stand, the chair with the microphone. And they can either testify for you or against you. You have a right to ask them questions. If you're representing yourself, your attorney is representing you, your attorney can ask them questions. We call it either direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses to come to court. That simply means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because the state will be calling witnesses in their case. You also have what is called a Fifth Amendment right against self-incrimination. And the Fifth Amendment right against self-incrimination basically means that you have a right not to testify in your own case. I know we watch television, law shows on television, and this year a person say, well, I take the fifth. That means I'm not saying nothing. Okay. And so you have a right, you have a Fifth Amendment right against self-incrimination that you choose to exercise. That simply means that the state of Texas, the district attorney's office, or the government cannot force you to take the witness stand if you exercise or invoke your Fifth Amendment right against self-incrimination. Now, you can waive or give up your Fifth Amendment right against self-incrimination. If you do so, that simply means that you will be taking a witness stand. Now, you also have a right to have discovery. Discovery means that you have a right to have access to the evidence that the state has and will be using against you. That is, you have a right to see witness statements, your statements, police reports, lab reports. You have a right to see photos, video recordings, listen to audio recordings, have access to any type of instruments that they may have, documents. You have a right to have access to that. Now, you can waive or give up your right to discovery as well. If you waive or give up your right to have discovery, then you will not be having access to none of the evidence that the state will be using against you. Now, everyone that's here today, you're here and you have a case in this court and you've been arrested. That means you was arrested, placed in jail, and you're out of jail on bond. You're either out of jail on what is called a cash bond, which means that you paid the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means that you paid a bondsman a percentage of the bond to get out of jail. Or you're out of jail on what is called a PR bond or personal recognizance bond, which means that you did not have to pay any money to get out of jail. You was released under your own personal recognizance with a promise to appear here in court. Now, every day that you spent in jail, that jail time can be used as credit toward your punishment. So, for example, let's say you spent 5 days in jail, and let's say you and the state have reached a plea bargain agreement for you to serve 5 days in jail. That means you won't have to serve any time in jail because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you've already served. Now, if the state is offering for you to serve 7 days in jail and you serve 5 days in jail, that simply means you won't have to serve 2 days in jail, because we'll take the 5 days from the 7 at least 2. Now, every day that you spent in jail also can be used as credit toward your fine and court costs. You will receive $100 for every day that will be credited toward your fine and court costs. So if you spend 5 days in jail, that's $500. So if the state is offering you fine and court costs of $500, you won't have to pay it. Why? Because you've already paid it off by serving 5 days in jail, which is $500. Now, if they're offering for you to serve, say, 7 days in jail, you've already served 5. That means that you will only, no, if they're offering you to pay $700 fine and court costs, and you serve 5 days in jail, which is $500, that means you only have to pay $200. You would have to pay that $200 on the day of the plea. Now, if you cannot pay the $200, no problem, because we can put you on a payment plan. Now, if you can't pay off the payment plan, then we can convert your $200 to community service. You will receive $12.50 for every 1 hour of community service that you perform. So if you work 8 hours of community service, that's $100 that will go toward your fine and court costs. So in the scenario that I gave, you owe $200. We converted it to community service. You just have to work 2 8-hour days, and that will be $200, and you'll be finished with your fine and court costs. All right. Now, if you haven't been in trouble before, Jefferson County or the District Attorney's Office has a program that is called pretrial diversion. With that program, they will dismiss your case, and you can get it expunged from your record. Expunged means wiped off, deleted, or erased from your record. Now, in order to qualify, you have to, as I mentioned earlier, it has to be your first time getting in trouble. You have to get an attorney to assist you at filling out and making the application or submitting the application to the District Attorney's Office. And it cannot be an offense for resisting arrest, unlawfully carrying a weapon. Now, if you qualify, you can get in the program. They will, once you get in the program, they will dismiss the case. You complete the program, then you can get it expunged, which means erased, deleted, or wiped off from your criminal record. Now, if you are a veteran of any one of the branches of the United States military, the District Attorney's Office has a program called Veterans Court. Only thing you have to do to get in that program is be a veteran of any one of the branches of the United States military. With that program, once you get in the program and complete the program, they will dismiss your case. And you can get what is called a non-disclosure. As I mentioned earlier, the non-disclosure is where your record is sealed to the general public. Now, if you're interested in any one of those programs, just let us know, and we can get you, direct you to the person that you need to talk to, or get you the paperwork that you need to fill out. Now, this court, County Court at Law number 2, has a program that is called CSI program. The CSI program is a program that I started within the first 100 days of taking office. Started the program in March of 2017. So we've had that program for the past 7 years. And so with that program, the CSI program stands for Community Safety Initiative. The program is designed to address the issue of what we call recidivism. Recidivism is where a person, continues to commit crimes over and over. And so we address it through our Community Safety Initiative. Within the Community Safety Initiative, or the CSI program, we have partnerships with various agencies in our Southeast Texas community. One agency that we have a partnership with is the Spindletop Center. Spindletop is our local or regional mental health center. Now, with Spindletop has the expertise to address your mental health issues. For example, you don't have to be incompetent or insane to participate in the program. You can merely suffer from anxiety or depression or any other host of mental illnesses. And Spindletop has the expertise to address your mental health needs. Now, what Spindletop will do initially, they'll conduct a private interview. The interview could be conducted either in our jury room, or it could be conducted at their facilities, or they can conduct it over the phone. And the next thing they will do, they have the ability to perform an assessment to determine what your issue is. And once they perform that assessment, then they could either refer you to either outpatient or inpatient treatment, depending on your mental health needs. Now, if you have issues with alcohol or drugs, well, Spindletop has a program that is called ATAR. It's an acronym that stands for Addiction, Treatment, and Recovery. We also have a partnership with our local Drug and Alcohol Council that has a program that is called OSAR. OSAR is an acronym that stands for OSAR, that stands for Outreach, Screening, Assessment, and Referral. Both programs are designed to address issues of alcohol and drug abuse. And with those programs, they have the ability to do screening, an assessment, and then develop a treatment plan for either outpatient or inpatient treatment. Now, if you are unemployed, do not have a job, or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called, the acronym is CICE, and it stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you are trained in any one of those areas, they will help you and they will get a job for you in the area that you're trained in. Now, if you have not graduated from high school or if you do not have your GED, then CICE also has a GED program, which you receive your graduate equivalency diploma. Now, all of these programs that I just mentioned are free. And that simply means that it does not cost you anything but time. And I like to say in this court, we do not just give time, we take our time. That is, we do not just arrest the problem, we address the problem. And that is, if we address the problem, we believe that we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say, when you come to county court at law number 2 in Jefferson County, Texas, we don't have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, then we will make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs, just let us know, and we'll be happy to give you, provide you with the information that you need to get into these programs. Now, the paperwork that you have on the clipboard, as I mentioned earlier, we're going to pick that paperwork up. I'm going to pick that paperwork up from you. Now, if you need some help filling out the paperwork, just let us know by raising your hand, and we have our personnel, our core personnel, who's here, who will be happy to assist you with filling out the paperwork. Now, once the paperwork is filled out, then we'll pick it up, and then we're going to go through it, and we're going to call you up to the bench. This is the bench, one at a time. And then, depending on whether or not, if you want to hire an attorney, or whether or not you want to, whether or not you're requesting or asking for a court-appointed attorney, or whether or not you want to waive your right to attorney and represent yourself, we're going to put you in one of those 3 categories. And then once your case is finished, for those whose cases are being reset, or if a person is given an attorney, then you'll see the court coordinator. And once you see the court coordinator, then your case will be finished for the day. Okay, so this is going to take us a few minutes to pick up the paperwork from you. Now, if you need to use the restroom, there are 2 restrooms right out in the hallway. The men's restroom is next to county court at law number 3. The women's restroom is on the opposite side of the hall, in front of the 172nd District Court. So you'll be allowed to, go out into the hallways, use the restrooms. Now, do not leave the courthouse. And the reason why I'm saying that is because if you leave the courthouse, and if we call your name and you're not here to answer, then your bond can be forfeited and a warrant can be issued for your arrest. Okay? So at this time, the court is going to go into recess. Just raise your hand. Those of you who need help with the paperwork, and we have our court personnel who will be here to help you with your paperwork. Okay? Okay. Court will be in recess. Jefferson County Court at Law number 2 is back in session with the arraignment docket. First case is cause number 24CCCR 0810, case of style of the state of Texas versus Patrick George Pleasant. Mr. Pleasant, would you please come forward? Mr. Pleasant, your full name is Patrick George Pleasant.
Yes, sir.
How are you doing, Mr. Pleasant?
Marvelous.
Hmm?
Marvelous. How are you?
I'm doing fine. Thanks for asking. Now, Mr. Pleasant, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
Mr. Pleasant, give me Mr. Pleasant still. You can put your hand down, Mr. Pleasant. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document? And is this your signature on the line that's titled defendant? Are these your initials on the line that state you've hired an attorney whose name is Rife Kimler? Now, Mr. Pleasant, before you signed and initialed this document, did you read the document? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge?
Yes.
Where's the copy? Okay, Mr. Pleasant. Your case is going to be reset. Your attorney, Wright Kimler, has not informed us that he has been hired by you. And so you need to let him know that he needs to send the court a letter of representation.
Same email.
Hmm?
Email. He said he sent y'all email.
Well,
I'll let him know.
do we have something from Kimler saying he's hired? He's been hired.
Yeah.
Now, in the meantime, while she's looking for that, I need to give you some bond conditions. Okay. Now, Mr. Pleasant, I'm going to go over these bond conditions with you. Bond condition states as follows: standard bond conditions in County Court at Law number 2, following return of criminal information in County Court at Law number 2 of Jefferson County, Texas. All bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? The defendant shall not commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Now, condition number 3 and 4 does not apply. However, condition number 5 does apply. Condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actually engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? You cannot possess a firearm or ammunition. You understand that condition?
So. Nah,
Okay. Now, if you violate any one of these bond conditions, your bond can be revoked. If your bond is revoked, you'll be arrested, placed in the Jefferson County Jail. Now, please, your case is going to be reset by a court coordinator. Have a seat in that first chair. Once you reset your case, you'll be free to go. And have a blessed day. Next case is Christopher Lee Glassy, cause number M 333-340. Mr. Glassy, your full name is Christopher Lee Glassy.
Yes, sir.
Mr. Glassy, would you please raise your right hand? Mr. Glassy, do you swear affirm to tell the truth, the whole truth, and nothing but the truth so help you God? Mr. Glassy, you may put your hand down. How are you doing, Mr. Glassy? That's good. Mr. Glassy, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials on the line that state you've hired Giles Cole as your attorney?
Yes, sir.
Now, Mr. Glassy, Mr. Cole has not sent us a letter of representation, I don't think. And so your case is going to be reset. You need to tell Mr. Cole he needs to send the court a letter of representation. Your case is going to be reset. Once your case is reset, you'll be free to go and you have a blessed day. Just have a seat on that third chair on the wall. Here you go. Moses. Carlton Ford. Mr. Ford, your full name is Carlton Ford?
Third.
Okay, didn't have that on. Let's see. Okay, how are you doing, Mr. Ford? That's good, Mr. Ford. They have you down as Carlton Joseph Ford.
Yeah, that's what I called Joseph.
Okay, Mr. Ford, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Ford, you may put your hand down. How are you doing, Mr. Ford? That's good, Mr. Ford. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document?
I was trying to hire one.
Okay, my question was, do you recognize the document?
Yes, sir.
Okay, is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you'd like to reset your case to hire your own attorney?
Yes, sir.
Okay, now, Mr. Ford, before you signed this document, did you read the document?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Ford, your case is going to be reset by our court coordinator. But before she gives you the reset, I need to give you some bond conditions. Mr. Ford, the bailiff just handed you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Okay.
And it states, it reads as follows: following return of criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named here in order, subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Good. Condition
number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs, alcohol, in the defense spots. You understand that condition? And condition number 3 and 4, they do not apply. However, condition number 5 does apply. Condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, active to engage in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that?
Yes, sir.
Now, Mr. Ford, if you violate any one of these conditions, your bond will be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested, you'll be arrested and placed in the Jefferson County Jail. Do you understand that? Okay, now, Mr. Ford, please have a seat in that first chair. Wait for your name to be called. Once your name is called, you're free to go and you have a blessed day. Next case, Crystal Hebert. Okay, this is cause number M 328-998. Case is styled the state of Texas versus Crystal Hebert. Ms. Hebert, would you please raise your right hand? Ms. Hebert, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Hebert, you may put your hand down. How are you doing, Ms. Hebert?
I'm fine, I want to say.
I'm doing fine. Thanks for asking. Ms. Hebert, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Mhm.
And is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
And on page 2 of the same document, there's a signature above the line that is titled defendant signature. Is this your signature?
Yes, sir.
Ms. Hebert, before you sign any initial these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Hebert, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that would be appointed to represent you in this case is Attorney Peter Dahl. Attorney Dahl will be given information to contact you. You will be given information to contact him. And the court coordinator will give you that information. But before she gives you that information, the bailiff is going to give you some bond conditions that I need to go over with you. And the bond conditions, this title, Standard Bond Conditions in County Court Law Number 2, following return of a criminal information in County Court Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are already subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense. The defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes.
Now, condition number 4 does not apply. However, condition number 5 does apply. And it states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by Section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, Ms. Hebert, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, warrant issued for your arrest, you'll be arrested and placed in the Jefferson County Jail. Please have a seat in that chair, the first chair by the wall. Once you get your paperwork, you're free to go, and you have a blessed day.
Yes, sir.
Shy Brooks. Mr. Brooks, your full name is Shy F. Brooks. Mr. Brooks, would you please raise your right hand? Mr. Brooks, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Brooks, you may put your hand down. How are you doing, Mr. Brooks? That's good. Mr. Brooks, I have before me two documents. The first document is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that's titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
And on page 2 of the same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Ms. Brooks, before you sign and initial, Mr. Brooks, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Brooks, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney Mark Faggart. Attorney Faggart will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go and you have a blessed day. Please have a seat in that first chair on the wall. You're welcome. Next two cases, Gary Darcy III. Mr. Darcy, let's see. Your full name is Gary Darcy III. Is that correct? Mr. Darcy, would you please raise your right hand? Mr. Darcy, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, how are you doing, Mr. Darcy?
Good.
You doing good? That's good. Yeah, I'm doing fine. Thanks for asking. Mr. Darcy, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document?
Sir.
Is this your signature on the line that's titled Defendant?
Mm-hmm.
And are these your initials on the line that states you'd like to apply for a court-appointed attorney?
Sir.
I also have another document that's titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Mr. Darcy, before you signed and initialed these documents, did you read the documents? Did you understand what you read?
Mm.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge? Mr. Darcy, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that's appointed to represent you is Attorney David Grove. Attorney Grove will be given information to contact you, and you will be given information to contact him. But before the court coordinator give you that information, the bailiff is going to give you some bond conditions. And the bond conditions, I'll go over those bond conditions with you. And it states as follows: standard bond conditions in County Court at Law number 2. And it says, following the return of criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition? You understand that?
Yes.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes.
And condition number condition number 3 and 4 does not apply. However, condition number 5 does apply. The defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by Section 107. The Penal Code actively engaged in employment as a sworn full-time paid employee or state agency or political subject. Do you understand that condition?
Yes, sir.
Now, Mr. Darcy, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, Mr. Darcy, please have a seat in that first chair on the wall. Once the court coordinator gives you a reset, you're free to go and you have a blessed day. Jenny Barlow. How you doing, Ms. Barlow? Now, Ms., how do you pronounce your middle name? Laniqua? Okay. Ms. Barlow, your full name is Jenny Laniqua Barlow? Ms. Barlow, would you please raise your right hand? Ms. Barlow, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Barlow, you may put your hand down. How are you doing, Ms. Barlow?
Okay.
I'm doing fine, thanks for asking, Ms. Barlow. I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Ms. Barlow, do you recognize this document?
Yes, sir.
Is this your signature on the line? It's titled Defendant?
Yes, sir.
Are these your initials on the line that state you'd like to apply for court-appointed attorney? Okay, I also have a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yeah.
And on page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes.
Ms. Barlow, before you sign and initial these documents, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Ms. Barlow, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. An attorney that will be appointed to represent you in this case is Attorney Benjamin Jeffries. Attorney Jeffries will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. But before she gives you that information, the bailiff is going to give you some bond conditions that I need to go over with you. And Ms. Barlow, the document that you've just been handed is titled Standard Bond Conditions in County Court at Law number 2. And it reads as follows: following the return of criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release for any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state or the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test in the case of presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 states that the defendant shall not communicate either directly or indirectly with the alleged victim of a pending offense. And the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? Now, condition number 4 does not apply. However, condition number 5 does apply. And the state defendant is prohibited from possessing firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Now, Ms. Barlow, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in Jefferson County Jail. Now, your case is going to be reset by a court coordinator. Once your case is reset by the court coordinator, you'll be free to go, and you have a blessed day. Please have a seat in that 3rd chair on the wall.
You too. Thank you.
You are. Houston Sanye. Mr. Sanye, would you please raise your right hand? Sanye, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. Mr. Sanye, your full name is Houston Sanye?
Yes, Houston James.
Houston James Sanye. Okay, how are you doing, Mr. Sanye?
I'm blessed. How are you?
I'm blessed as well. Thanks for asking. Mr. Sanye, I have before me a document that is titled There's an explanation of rights to defendants without attorney. Do you recognize this document?
Oh, yes, sir. I think I misread that one. I was gonna hire my own.
Okay, okay, I'll get there. Is this your signature on the line that's titled defendant?
Yes.
And are these your initials on the line state you want to hire your own attorney?
Yes.
Now, Mr. Sonia, before you sign and initial this document, did you read the document? Did you understand what you read? Is everything in this document true and correct to the best of your knowledge? Mr. Sonia, your case is going to be reset. Just have a seat in that 3rd chair on the wall.
Your Honor, all 3 are taking the state's offer.
Okay, okay. What it does it need?
The wire program to get hired.
Oh, do you have one? Hold on a minute.
It's okay.
I have one right here. Here you go. Got a whole bunch of whole stack. There you go.
Thank you very much.
All right, you up. And what's his name? What's your name? Darcy, okay. Who did we appoint for Mr. Darcy? David Rowe. Next case is cause number 24 CCCR 0806, case of style of state of Texas versus Marco Antonio Carrillo. Mr. Carrillo, your full name is Marco Antonio Carrillo?
Yes.
Mr. Carrillo, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Mr. Carrillo, you may put your hand down. How are you doing, Mr. Carrillo?
Fine.
I'm doing fine. Thanks for asking, Mr. Carrillo. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
Is this your signature on the line as titled defendant? And are these your initials on the line state you would like to apply for a court appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
And on page 2 of the same document, there's a signature above the line that's titled defendant signature. Is this your signature?
Yes.
Mr. Carrillo, before you signed and initialed this document, did you read the documents?
Yes.
Did you understand what you read?
Yes.
Is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Carrillo, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court appointed attorney. The attorney that will be appointed to represent you is Attorney Jack Lawrence. Attorney Lawrence will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get the information from the court coordinator, you're free to go. You have a blessed day. Please have a seat in the first chair on the wall.
Judge, you have something else? She wants it.
What's your name? Here you go. Ms. Porlo. All right, there's a number at the bottom you can call.
Everything that I need to know from them.
Yeah, you can call it. Yeah, the number. Yeah. All right, you're welcome. You working on that, please? You did?
Session is closed.
Jefferson County Court at Law number 2 is back in session. The court is in session in cause number M334066. Case is style the state of Texas versus Jessica B. Willis. Ms. Willis, is that your full name? Ms. Willis, would you please raise your right hand? Ms. Willis, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God? Ms. Willis, you may put your hand down. How are you doing, Ms.? You doing good? That's good. Ms. Willis, I have before me a document on my computer that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Ms. Willis, it alleges that you, Jessica B. Willis, on or about September 24th of 2022, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of failure to identify a fugitive from justice. Ms. Willis, before we go any further, Ms. Willis, you have a right to have this proceeding recorded, or you have a right to have a court reporter to record everything that's being said. Do you waive or give up that right? Okay. Now, Ms. Willis, before me, I have State's exhibit. Well, I'm gonna go back over the information. This information alleges that on or about September 24th of 2022, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of failure to identify fugitive from justice. Ms. Willis, do you understand what you've been charged with? And to this charge, how do you plead? Guilty, not guilty, no contest. Now, are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty? Ms. Willis, I also have before me a document that is titled Misdemeanor Plea Admonishment. It's also labeled as State's Exhibit number 1. You recognize this document? On page 2 of the same document, there's a set of initials, 2 sets of initials. First set of initials below a paragraph titled waiver, and it's on a line next to a box that's checked guilty. Did you place your initials on this document? The second set of initials are below a paragraph that's titled discovery admonishment. It's on a line next to a statement that reads, I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials on this document right here? On page 3 of the same document, there's a signature below the line that's titled defendant. Is this your signature? On the next document, that's titled trial court certification of defendant's right of appeal, you recognize this document. And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. You understand that statement. The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. You understand that statement? Now, Ms. Willis, before you signed and initialed all of these documents that I just showed you, did you read the documents? Did you understand everything that was went over? And is everything in this document true and correct to the best of your knowledge? Ms. Willis, are you a citizen of the United States? State is offering this document, State's Exhibit, the first document, State's Exhibit number 1, to be used as evidence in your case. State's Exhibit number 1 is the first document that you acknowledge, that you recognize. It'll also the same document that you acknowledge your initials, these 2 locations on page 2, and your signature on page 3. Is it all right for the state to use this document as evidence in your case? No objection. State's Exhibit number 1 will be admitted. Ms. Willis, is there any evidence that you are currently mentally incompetent to stand trial? Okay, Ms. Willis, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
We do, Your Honor.
And what is the agreement?
The agreement is 124 days time served, scored by second retired.
Okay, Ms. Willis, the state is offering that you serve 120 days in Jefferson County Jail. However, you will not have to serve any more time in the Jefferson County Jail because you've already served 124 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you would not be required to pay court costs in this case because you've already served enough time to pay off the court costs in this case. Ms. Willis, do you understand the state's offer?
Yes, sir.
Do you think the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
And before we do that, Ms. Willis, I need to back up. I have before me, Ms. Willis, a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line is titled defendant? And are these your initials on the line that state you would like to waive your right to attorney and represent yourself? I also have another document that's titled Waiver of Counsel for Purposes to Enter a Guilty Plea or Proceed in the Trial. You recognize this document? And is this your signature on the line that's titled defendant? Now, before you sign and initial these documents, did you read the document? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, now, Mr. Willis, as I mentioned earlier, we're going to follow the plea bargaining agreement that you've entered into with the state. And Ms. Willis, I understand that just from looking at your file, you have spent some time in jail on another case and accumulated a lot of time on this case. Is that correct?
Yes,
All right. You're gonna stand next to the bailiff, follow her direction. Once you finish following her directions, you're free to go and you have a blessed day. Rashad Runners. Mr. Runners, your full name is Rashad Deshaun Runners. Mr. Runners, would you please raise your right hand? Mr. Runners, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? So help you God. Mr. Runners, you may put your hand down. How are you doing, Mr. Runners? I'm doing fine. Thanks for asking. Now, Mr. Runners, you have a right to have a court reporter to dictate everything that's being said in this proceeding. You also have a right to waive or give up the right to have a court reporter. You waive or give up the right to have a court reporter? Okay, you do? Okay. Now, Mr. Runners, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office against you. In this information, it alleges that you, Rashad Deshaun Runners, on or about January 27th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of unlawfully carrying a weapon. Mr. Runners, do you understand what you've been charged with? And to this charge, how do you plead? Guilty, not guilty, or no contest? Now, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Runners, I also have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Mr. Runners, do you recognize this document? And is this your signature on the line as titled defendant? And are these your initials on the line state you'd like to apply for, that you would like to represent yourself and waive your right to an attorney? Now, Mr. Runners, I also have another document that's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document? And is this your signature on the line as titled defendant? I also have another document on my tablet that is titled Misdemeanor Plea Admonishments. Do you recognize this document? On page 2 of this document, there are 2 sets of initials in 2 different locations. The first set of initials is located below a paragraph that is titled waiver, next to a line it says guilty. Hold on a minute, wrong one. Let me back up. Hold on a minute. I'm gonna send this one back to you. You're gonna send it back to me. Let me. Okay. Okay, Mr. Reynolds, I have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document? Now, on page 2 of this document, there are 2 sets of initials. First set of initials is the lower paragraph that's titled waiver, and it's on a line next to a box that's checked no contender, which means no contest. Did you place your initials RR on this document?
Yes, sir.
The next set of initials RR is located below a paragraph that was titled discovery and admonishment. And it is next to a statement that reads as follows: I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials on this document? On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature? And on the next document that's titled trial court certification, the defendant's right of appeal, you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right to appeal. Do you understand this statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Mr. Runners, before you sign and initial all of these documents that I just showed you, did you read the documents? And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Runners, are you a citizen of the United States?
Yeah, for stage 1.
Mr. Runners, the state is offering State's Exhibit number 1 to be used as evidence in your case. State's Exhibit number 1 is the first document that I showed you on this tablet. It is the same document that have your initials on the 2 locations on page 2 and your signature on page 3. Is it all right for the state to use this document as evidence in your case? Okay. No objection, State's Exhibit number 1 will be admitted. Okay, now, Mr. Runners, is there any evidence that you're currently mentally incompetent to stand trial? Okay, Mr. Runners, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. Will you drop
It's
something?
okay, you can get it.
Okay. State, do we have a plea bargain agreement in this case?
We do, Your Honor.
And what is the agreement?
For defendant's plea, the state has offered 6 months deferred probation with the fine waived, 24 hours community service, and forfeiture of the firearm involved in this case.
What is the court cost?
277.
Okay. Mr. Runners, the state is offering that you serve 6 months deferred adjudicated probation. During the 6 month probationary period, you'll not be required to pay a fine. The state is waiving the fine in this case. However, you will be required to pay court costs of $277. You'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month, is $148 a month. Will you be able to pay the $148 each month?
Yeah.
You will also be required to perform 24 hours of community service. And the weapon in this case will be forfeited to the Beaumont Police Department. I have before me a motion to forfeit. Do you recognize this motion? And is this your signature on the line that's titled defendant? Now, before you sign this document, did you read the document? You understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay. And the court is going to grant this motion to forfeit the weapon in this case to the Beaumont Police Department. Now, Mr. Runners, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Mr. Runners, I'll follow the people in agreement that you have entered into with the state. Mr. Runners, if you successfully complete this probationary period, this case would not result in a conviction on your record. The case would be dismissed and you may qualify for a non-disclosure. You can talk to an attorney about the non-disclosure. Okay? Now, I need to hand you, the prosecutor's gonna hand you a document that is titled Model Written Ammunition on Ineligibility to Possess a Firearm or Ammunition. And I'm going to go over this document, which it says in accordance with the Texas Administrative Code, section 176.1, the court hereby admonishes you of the following. Number one, you are by entry of order of judgment ineligible under Texas law to possess a firearm or ammunition. Number two, beginning now, if you possess a firearm or ammunition, it could lead to charges against you. If you have questions about how long you will be ineligible to possess a firearm or ammunition, you should consult an attorney. Number three, under Texas Penal Code Section 46.013A, firearms mean any device made, designed, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance or any device readily convertible to that use. B, firearm does not include a firearm that may have, as an integral part, a folding knife blade or other characteristics of weapons made illegal by Penal Code Chapter 46, and that is one, an antique or curio firearm manufactured before 1899, or two, a replica of an antique or curio firearm manufactured before 1899, but only if the replica used rimfire or centerfire ammunition. The statutes listed below are a starting point for ineligibility to possess a firearm or ammunition. For more information about the laws that make you ineligible to possess a firearm or ammunition, you should consult an attorney. Now, Code of Criminal Procedure, Article 17.292, Magistrate's Orders for Emergency Protection. Code of Criminal Procedure, Article 42.0131, Notice of Persons Convicted of Misdemeanors Involving Family Violence. Penal Code Section 46.02, Unlawful Carrying Weapons. Penal Code Section 46.04, Unlawful Possession of Firearm. Penal Code Section 25.07, Violation of certain court orders and conditions of bond in a family violence, child abuse or neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case. Family Code Section 85.06, Warning on Protective Orders. Now, Mr. Runners, the model written ammunition that you have before you is for your records. Please stand in front of our court coordinator, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you're free to go. and you have a blessed day. You're welcome. Next case is cause number 24CCCR 1422. Case is style of state of Texas versus James Cole Easley. Mr. Easley, your full name is James Cole Easley. Mr. Easley, would you please raise your right hand? Mr. Easley, do you swear or affirm, tell the truth, the whole truth, and nothing but the truth, so help you God?
Yep.
Mr. Easley, you may put your hand down. How are you doing, Mr. Easley? I'm doing fine, thanks for asking. Mr. Easley, you have a right to have a record made of this proceeding. You also have a right to waive and give up your right to have a record made by a court order. I'm gonna send this, I'm gonna send this back to you. Could you send it back to me? Actually, it should already be there. You can send it back.
I'm sending it.
Okay. Now, Mr. Easy, let me go back over this here. I have before me a document, I have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Easley, it alleges that on or about May 3rd of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of resisting arrest. Mr. Easley, do you understand what you have been charged with?
Yes.
And to this charge, Mr. Easley, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you are guilty?
I'm guilty.
Okay. Now, Mr. Easley, I also have before me on paper two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Mm-hmm.
Are these your initials on the line that state you'd like to waive your right to an attorney and represent yourself?
Sure.
I also have another document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. Do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant? Okay. I also have a document on this tablet, two documents on this tablet. First document is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes.
On page 2 of the same document, there are two sets of initials, JE. The first set of initials is below a paragraph next to a box that says check guilty. You place your initials on this document.
Yep.
The second set of initials is below a paragraph that's titled discovery, admonishment, and they're on a line next to a statement that reads as follows. I do not request discovery of the evidence. I waive my right to request discovery in this case, and choose to enter a plea of guilty or no contest. Did you place your initials on this document?
Yes.
On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document is titled trial court certification of defendant's right of appeal. Do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
Now, Mr. Easley, before you signed and initialed all of these documents that I just showed you, did you read the documents?
I did.
And did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Easley, are you a citizen of the United States?
Stay
State,
on for stage one.
okay. States is offering States Exhibit number 1 into evidence. States Exhibit 1 is the first document that you acknowledge on the tablet. It is the same document that you acknowledge where you acknowledge your initials was on page 2 in the 2 locations and your signature on page 3. The state would like to use this document as evidence in your case. Is it all right for the state to use this document as evidence in your case?
Yes.
Okay, no objections. State's Exhibit number 1 will be admitted. Now, Mr. Easley, is there any evidence that you are currently mentally incompetent to stand trial?
Sir.
Okay, Mr. Easley, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in
We
this
do.
case? And what is the agreement?
The agreement in this case for defense plea of guilty is 90 days probated over 1 year with a $400 fine and 50 hours community service.
Okay. What is this court cost?
Easy, 277.
Okay, Mr. Easley. The state is offering that you serve 90 days in Jefferson County Jail, but you would not have to serve any time in the Jefferson County Jail on this case because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $400 plus court costs of $277. You'll be required to pay a probation fee of $60 a month, a urinalysis fee of $15 a month, and a reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $145 a month. Will you be able to pay the $145 each month?
Yes.
You will also be required to perform 50 hours of community service. And you will be required to adhere to the other standard terms and condition of this probation. Mr. Easley, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Perfectly fair.
And do you accept the state's offer?
I do.
Mr. Easley, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Easley, this will conclude your case. You're going to stand in front of the court coordinator, follow her directions. Once you finish following her directions, and following the directions of the bailiff, you'll be free to go. And you have a blessed day.
Thank you very much.
You're welcome. Okay.
You got it. That's cool. No. Yeah.
Okay. Next case, bond forfeitures is Chastity Faith Eve. This is cause number 24CCCR 0802, case of style of state of Texas versus Chastity Faith Eves. Chastity Eve was scheduled to be in court this morning at 9 a.m. At or about 9 a.m. The court's really called the name of Chastity Eve at the courthouse door. Chastity Eve did not answer. Chastity Eve has not appeared in court since the court has been in session. The time now is 11:55 a.m. on today's date of August 20, 2024. Ms. Bailiff, would you please call the name of Chastity Faith Eves or Chastity Eves at the courthouse door? Chastity's names are called again at the courthouse door. Chastity Eve did not answer. A reasonable time has passed to give Ms. Eves an opportunity to appear in court. She has not appeared in court. State, do you have a motion?
Statements upon forfeiture.
That motion will be granted. Next case is cause number M332342, case of style of state of Texas versus Brendan Anthony Pitts. Brendan Pitts was scheduled to be in court this morning for arraignment at 9 a.m. At or about 9 a.m. The court's bailiff called the name of Brendan Pitts at the courthouse door. Brendan Pitts did not answer. A reasonable time has passed to give Mr. Pitts an opportunity to appear in court. He has not appeared in court. The time now is 11:06 a.m. on today's date of August 20th of 2024. Ms. Bailiff, would you please call the name of Brendan Pitts at the courthouse door?
Brendan Pitts.
Brendan Pitts' name was just called at the courthouse door. Brendan Pitts did not answer. A reasonable time has passed to give Mr. Pitts an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
Statements upon forfeiture.
That motion will be granted. Did we have did Damian Lewis Thibodeau appear?
That was the one went to jail with the felony.
What about him, Judge?
He went to jail.
You say he had some felony warrants?
Yeah,
I'm still with her.
he was in.
Yeah, I know.
Um,
Well, we didn't get a chance to arraign him. He's not still back there, is he? Yeah.
Judge, I don't know about Chastity Eve being a good forfeiture. I don't feel the court that about him.
Okay, Chastity Eves. Okay, so we're gonna State, you gonna recall upon forfeiture on that? It says she wasn't given notice.
No notice was given, state will recall one.
So we're gonna have to reset that. What about the other person?
The bondsman was notified on that one.
That was Pitts?
Yeah.
Yeah,
He is,
he is?
yes,
Okay, have him come on out. I could,
have him.
yeah, you can bring him on out. That's, that's Thibodeau?
Yeah.
Now, Mr. Thibodeau, give him judge's explanation of rights to defendants without attorney. Now, Mr. Thibodeau, you're scheduled for arraignment today in your misdemeanor cases. And I know there were some warrants out on the on your felony cases. And so we're going to give you your rights to have an attorney. In this case, we're going to provide you with a judge's explanation of rights to defendants without an attorney. And basically what the document basically states that as a defendant in a criminal case, she's gonna hand it to you. As a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Do you understand that option? You have to speak up. Okay, number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent. Do you understand that option?
Yes.
And number three, you may represent yourself. That is, waive your right to an attorney and represent yourself. You understand that option? Now, if if you want an attorney, you have enough money to hire an attorney, your case will be reset to give you time to hire an attorney. If you want an attorney, but you do not have enough money to hire an attorney, then you can request that an attorney be appointed to represent you, but you must first fill out a financial affidavit. The affidavit on that clipboard is titled Jefferson County Affidavit of Indigence. You would have to fill out the first page and half of the second page. I will fill out the bottom half of the second page and the third page. Do you understand?
Yes.
Now, once you fill out that document, the proper person will determine whether or not you qualify for an appointment of a court-appointed attorney. Now, if you desire to waive or give up your right to have an attorney and desire to represent yourself, then before you do that, you have to read and sign a document on the clipboard that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. Do you understand? Now, that document, the waiver, basically states that you're aware that you have a right to have an attorney. And it states that you have been advised of the nature and charges against you and the dangers and disadvantages of self-representation. Now, let me tell you this. The waiving your right to an attorney and representing yourself may result in a worse outcome for you, including your case, and it may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Do you understand that? Now, if you choose to waive your right to an attorney and represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Do you understand that? Now, at the bottom of that document, in bold letters, it states defendant's choice. Mark initials next to only one choice. If your choice is to hire your own attorney, you put your initials on the first line to the left. If you have already hired an attorney to represent you in your case, you'll put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to apply for a court-appointed attorney, you'll place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you in your case, you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is to waive your right to an attorney or give up your right to an attorney and represent yourself, then you will place your initials on the fifth line to the left and the name of the attorney. Well, you'll place your initials on the fifth line to the left. Now, at the bottom of that document, it has a line that says defendant signature. You sign your name on the line that is titled defendant, and you will date it today's date, August 20th, 2024. You understand? Thank you. Now, he can have a seat if he needs to, fill out the financial affidavit, right? He can have a seat, and fill that out.
No luck with, or get in contact with their attorney.
Oh. Yeah. Let me do this here. Okay. Now, the court is back in session in cause number M 332-396. The case is styled the state of Texas versus Damian Lewis Thibodeau. Mr. Thibodeau, is that your full name? Mr. Thibodeau, would you please raise your right hand? Mr. Thibodeau, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Thibodeau, you may put your hand down. Now, Mr. Thibodeau, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant?
Yes.
Are these your initials on the line that state you like to apply for a court-appointed attorney?
Yes.
I also have another document that's titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
And on page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Mr. Thibodeau, before you signed and initialed these documents, did you read the documents? Did you understand what you read?
Yes.
And is everything in these documents true and correct, best of your knowledge?
Yes.
Mr. Thibodeau, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you is Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you, and you will be given information to contact him. Our court coordinator will, are you gonna give him that information? Our court coordinator will give you that information. Once you get the information, just please follow the bailiff and you have a blessed day. Okay, please stand in front of the court coordinator. I'll take that. Here you go. And this will conclude the calling of the court's arraignment docket scheduled on today's date of August 20, 2024 in County Court at Law Number 2 of Jefferson County, Texas. Judge Terrence Holmes presiding. The court will be in recess until 1:30 for us to reconvene with our jury trial.